those are two different sets of rights that you're talking about that, and beliefs. One of the things that I believe is the separation of church and state. We're part of a political body. But the Constitution gives us rights from a legal standpoint. If the framers of the Constitution said certain things about religious ideals, that's fantastic. But, I mean, you really can't combine the two in a political standpoint, because we do have separation of church and state.
Right, that the state cannot establish a religion.
Correct.
Right, but when the preamble says, down there, there's inalienable rights given to us by our Creator, life, liberty, and pursuit of happiness, and you have a senator say, the government gives it to us, not a pre-government figure, aka the Creator, that actually is in our United States Constitution, the Declaration of Independence. So, but that's where you stand on that bit. So would you agree with this senator who says that our rights are given to us, those certain rights?
I believe we have rights, we have human rights just as humans. It doesn't matter what gives it to us. We have human rights that everybody's entitled to. I mean, we know what they are. I mean, they set forth in the Constitution. That's what our founding fathers set forth. And they gave us what our rights were.
No, they recognize that a priori the fact that those are our rights, and we acknowledge that we want to set up a federal government, given the restraints of those rights.
Okay?
Okay, I think one question at a time. So if,
Yeah.
go ahead. Are you finished with Jill's question? Or?
I think so.
Okay. Judge McDonald, would you like to address those?
Sure. The founding document that formally announced the separation of the colonies from Great Britain is the Declaration of Independence, signed on July 4, 1776. That document, which was authored by Thomas Jefferson, indicated in part, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. Among those are life, liberty, and happiness. That to secure these rights, governments are instituted among people, and the government derives their just powers from the consent of the people, not the other way around. The Bill of Rights functions as the legal connection to uphold the ideals of unalienable rights. So you've got your First Amendment, your Second Amendment, your Third Amendment, Fourth, Fifth, Sixth, Seventh, what have you. It upholds the ideal that those rights are unalienable rights that were granted to us by our Creator by turning into enforceable law and ideal, and ensuring that the government cannot take those away from people, cannot take away those inherent rights. Now, the law's changed a lot in the last 250 years. I think I remember the sound bite we were talking about, about 6 weeks ago during a Senate hearing. I don't know what the hearing was about, but there was a Democrat senator who was arguing that the United States is not like Iran. We're not run by a religious, I think he used the word junta, but I could be wrong about that, and that our rights come from the law. Senator Ted Cruz, who is certainly smarter than me, and seems to have the Declaration of Independence memorized, started saying what I just said. And he asked that Democrat senator, Have you ever heard of the Declaration of Independence? Do you not realize that we're endowed, as Attorney James said, with certain basic human rights? But I believe our founding fathers took that a step further. If you read further on in the Declaration of Independence, they have 2 pages of specific complaints that they had about the King of England, not allowing them to have jury trials, not allowing them to appoint their own local government, not allowing them to refuse to house British soldiers in their homes, not allowing them to arm themselves, not allowing them to have taxation with representation. So all of those are outlined in the Declaration of Independence. That came before the Constitution, and that is our founding document. So I do believe that there are unalienable rights that are granted to us by our Creator, and I don't believe the government has the right to take those away. Certainly, common sense will tell you free speech doesn't mean you can run into a theater screaming fire and cause a stampede where people are going to be killed. Certainly, the Second Amendment doesn't mean that mentally ill people should be allowed to have firearms. And I feel very strongly about that. I don't know if that answers your question or not.
Okay, thank you. John, did you have a question there? Okay, who's next?
Just to follow up with that question, Attorney James, I believe Jill was talking about the immutability of the natural law and how the Declaration recognizes the immutability of natural law and the laws that God has naturally given to man. And so my question to you and to Judge McDonald would be, do you believe in American exceptionalism as far as our legal system and our founding documents? Do you believe that America got it right? And do you believe that America is the last best hope for freedom in this world as compared to communist countries like China and other countries like Iran under Sharia law? So a government can establish laws. Going back to Martin Luther King's letter from Birmingham jail, he talks about the difference between a just law and an unjust law. And he said that a just law is a law that squares with the moral law and the law of God. He also referred to God. Our founders referred to God. If there are unjust laws and there are just laws, that means there certainly is a difference between what is a righteous law and unrighteous law. Martin Luther King Jr. says that unjust laws should be protested. So not necessarily from the bench, but that a judge should have a philosophy that squares with the founders' ideals and understanding of law and where that law comes from, so that we're always continuously pointing back to our original documents and getting a course correction in our nation, starting at the local level, a course correction back to constitutionalism and the understanding of what our founders' intent is. So, do you believe that there is a law that is immutable, that comes from God, and that some laws are unjust?
You're asking me repeat the question, I'm sorry, there were so many questions in that.
Yeah. Do you believe Do you believe in a natural law that is cited by our founders, that is immutable, that means it is unchanging, it applies to all men everywhere, their rights and what they ought to have protected by their governments? Or do you believe that there are such things as just laws and unjust laws?
Well, first of all, I believe that all men are created equal. All men should be treated equally. That's what our Constitution says. I think our Constitution and the Declaration of Independence are two of the greatest documents ever written. I think our justice system is fantastic. It's not perfect. There's a lot of work to be done. It changes all the time. There are laws that our courts strike down because they're not proper. They're wrong. But it's a work in progress. But I think, when I got into the legal field, I didn't know that I was going to feel that way. I thought, all right, I'm going to get a job. But I'm passionate about the law. I think our legal system can do so much good for so many people if done correctly. And that's why I continue to do what I do. That's why I'm running for this position. But all men are created equal. The Constitution says that. Our legal documents, they all say, or at least they should say, all men are created equal. And if there is an unjust law, our system gives us avenues for how to get rid of those unjust laws, modify them so that they are just. And that's why our system is so good. So that's my answer to the questions.
Okay, wow. That was one heck of a question. I tried to break it down. Let me just begin by talking about what I see as a dichotomy in the law. We talk about separation of church and state. That law, that amendment, was put in place to protect the church from the state, not to protect the state from the church. Somehow that's got flipped upside down in the past 250 years. Just to give you an example, every single day I'm swearing people in open court in Bloomsburg or Danville and saying, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. That's what all three judges say when we swear people in. And the President of the United States is sworn in. He's sworn in on a Bible. And there's a minister there to say a prayer. Every time Congress opens a new session, they pray. Every time the Supreme Court opens a new session, they pray. And yet we're told there's this separation of church and state. There is a lot of work to do there, as Attorney James said. That's one area where the law conflicts and doesn't make common sense to the average person. I do believe strongly and very firmly in American exceptionalism. I do believe this country is special. Why else would so many people around the world be trying to get into this country? It seems that the folks that were born here, in many instances, don't appreciate what we have. You've got people from all around the world doing everything they can to get here. If you've ever heard of the Darien Gap in South America, people die. Families die crossing through the Darien Gap. There's about a 60-mile area where there's no road, and they have to go through a mountainous trail. During that trek, they are attacked and assaulted by gangs, by drug enforcers. There are bodies and skeletons laying all up and down this Darien Gap. Look it up online. That's how badly people want to come to this country. So yes, I do believe in exceptionalism. I do believe we are one of the last bastions of freedom in this world, not just considering communist countries. Look what's happening in Great Britain right now with their speech laws. They're prosecuting people for simply stating their opinion. And it's not even something that we would call hate speech. It's people stating their opinion on social media. They lose their job, they can go to jail. And that's supposed to be one of the free countries in the world. To me, that's unjust. Our legal system, although not perfect, I think is the best legal system in the world to allow people to be heard. There are things that we can do. And in Columbia, in Montour County, there are things that the judges do to try and make things more fair. We have treatment courts. We have a drug court, DUI court, working on a mental health court, working on a veterans court. I could go on, but I believe very firmly and strongly in those courts. It costs $40,000 a year to keep one person incarcerated in the Columbia County Jail. I tried to get the figure from Montour County Jail and I wasn't able to get it today. So roughly $3,400 a month. And guess who pays for that? Property owners. It's your tax dollars. So, do I take a mentally ill person who has committed a retail theft for maybe the third time, which means even if they stole a $1 item, it's a felony, they're no danger to anybody, they're mentally ill, do I put them in jail? Is that good stewardship for the people of Columbia and Montour County of their tax dollars? I don't think so. I want to put them in treatment court because they're not a danger to hurt anybody. So those are a few areas where our law is exceptional. There are ways to change the laws if you don't like them. Constitutional amendments. The law is always developing. The legislature will pass a law, and then over a 10-year period, courts have interpreted that law. Not our level court, that's not what we do. But appellate courts will interpret that, and before you know it, they can't even recognize what the original statute was because they changed it so much. So, yes, this country is exceptional. Our legal system is not perfect, but it is exceptional. And I'm very, very passionate about protecting our community from truly dangerous people. Sometimes you make your bed and you have to lay in it. Those people have to go to jail. But there are other people who you might be able to work with in another way that's going to fix the problem that they had so that they're not a recidivist and we're not wasting taxpayer dollars. I'm not sure if we answered every facet of your question, but I tried my best.
Mark, if I can just.
I was gonna say, if you'd like to address some of the facets.
Just real quick, we do actually have a mental health court in Columbia and Montour County. It's referred to as the recovery court. So that's actually, it's a smaller court from the DUI and drug court, but we do have it.
Okay, we have a question here.
I do. This is for you, Tony. So there was a case in Montour County, it was a criminal case, and there was a plea deal that was set, and you, and bear with me on this, you wanted to take that to court, you wanted to do a trial. Can you explain why you wanted to do that?
I can explain this to you. That the newspaper got it wrong. I can't talk about the specifics of the cases because those people are still coming in front of me. I'll point you to the fact that the petition was filed and was immediately withdrawn the next day. point you to the fact that we have a case management order that's issued by the president judge that says prior to a jury term, a judge will tell the prosecution and the defense what days are available for trial, and that the prosecution will put a minimum of 2 cases on each day. I believe during that trial term, I gave the prosecution 5 days, which means they should have presented me with 10 potential trials. They took 3 days and gave me 5 potential trials. What I said was, what about these other days? Why aren't they full? I can't respond to a petition that's been withdrawn because it's moot. There's nothing for me to respond to. I can't hire a lawyer and respond to that. I can't talk about specific cases because the attorney who filed that petition withdrew it and then allowed all of her people to come in front of me. And some of those people are still awaiting sentencing. So that's.
If you could have done that any differently, would you have?
I'm sorry, I can't hear you.
I said, if you could have done that any differently, would you have?
I think that perhaps there was a failure in the communication, and the buck stops here, so I'm not going to blame anybody else for a failure in communication. It's not easy learning this job when you don't have a chance to go to judge school, and you're kind of learning on the job as you go. I'm already doing things differently than I did in February. So sure, anytime there's a controversy, you'd like to go back and perhaps word something a little differently or change something a little differently. And without getting into specifics, which will get me in very bad trouble, I can't answer the question.
Fair.
Okay, thank you.
Just from reading the reporting on it, and that's obviously all any of us know, it seemed like there were a number of plea deals that were put in front of you, and you, instead of accepting them getting scheduled, requested that one of them be go to trial. So like, that's how I read the reporting. That sounds like, can you explain to me kind of how that works? So it sounded, just reading the reporting, it sounded like, here are a number of plea deals, and then instead of you just scheduling them, you said, no, you pick one of these to go to trial.
That's what the report said.
Okay.
The report was wrong, and I can't respond to it any differently than I just did. I was supposed to be presented with 5 days of trials, stacked 2 deep. I was given 3 days of trial with 5 trials.
So you didn't demand that instead of them bringing you plea deals, one of them would be brought to trial?
Obviously, somebody took that as my intention. It certainly was not my intention.
Okay, thank
And
you.
I can't talk about the specific case because, once again, that petition was withdrawn so quickly, and then those very same people you're talking about, their attorney felt very comfortable allowing them all to come to court. And they did. And she's been continuing to bring her clients in front of me since then.
Okay, any, no.
No.
Yes.
Hi, my name is Sarah Tanner. I'm a resident of Montour County. And today's and judicial decisions are costly for people, financially, personally, for many other reasons. And I know this from personal experience with a drawn-out custody dispute. And my question is, what can our local judiciary and government officials do to improve the speed at which the system moves forward to ensure a swift and just decision? Thank you.
So I think that's one of the things that I focused my campaign on, is making sure that things get done quick. justice delayed is justice denied. First and foremost, enough department. Getting things done in a timely manner might mean instead of having a work day during the week, you have a work day on a Saturday. Scheduling. I think I have at least some ideas of how certain things that we do in Columbia and Montour counties take way too much time. We have pre-trial conferences, pre-hearing conferences for custody disputes and divorce hearings. I believe that those should not be scheduled for an hour, take an hour. I think they should be scheduled in a very immediate scheduling pattern throughout a day so that you can just get through all of them, because they don't take a lot of time. There shouldn't be a lot of wasting time back and forth, because the idea in there is to get an idea of what is going to happen in that proceeding. And I think that can save the courts a lot of time. But first and foremost, it's got to be the hard work. Second, it's got to be the scheduling. And there are a lot of things that, with the administration of the courts, that a lot of moving pieces where things are going to end up taking more time. But ultimately, when you have a proceeding in front of you, you need to make a decision as soon as possible. And I think spending the time, finding the time to do that is of the utmost importance. So that's my approach. And I also think making sure that the parties, the litigants, are taking part in all of their cases, whether it be these pre-hearings, pre-trials, will give a sense of transparency for the courts, so that people will more understand why something may take a little bit longer, but also give you as a judge a face to look at and rely on to be able to say, I need to get this done fast, I need to work a little bit later, I need to work a little bit faster and harder. So that would be my approach. That's what I've focused a lot of my campaign on.
Miss, I'm sorry, I didn't catch your last name.
Tanner.
Taylor?
Tanner. Tanner.
Thank you,
Yes, sir.
Miss. So, I have found, as judge, that I really have very little authority over how and when court administration schedules things. That's their own department. We'll talk about custody, but then I'd also like to go into the criminal arena. Custody and pre-trials are very valuable to the judge. As I said, sometimes you get a 2011 custody case that's still going on now. Sometimes you get a 2013 custody case that's still going on now. You literally have to take the time, as Attorney James said, to put in and truly try and understand that case. I am typically the last person out of the courthouse other than the second shift sheriff every day. Last Thursday I was there at 7:30 because I had one of those cases. Oftentimes you can settle matters at pretrial conferences and then you don't have to move on to a full hearing. That certainly saves everybody money. In a divorce case, for instance, it's my firm belief that if you have two good prepared attorneys and the judge has reviewed all of the information that the judge has, when you're at that pretrial conference and there's been open exchange of discovery and if there are two good attorneys, there has been, that both attorneys and the judge know within 10% either way where that case is going to come down. And if you talk it through during the pretrial conference and try and understand where each party is coming up with their numbers, you may start at 10%. All of a sudden you find yourself at 7%. Then you find, after a little more talking, you're really 3% apart. And then I say to the attorneys, go out and ask your folks. Do they want me, a complete stranger, to tell them what to do with their property and with their money? They're only 3% apart. It's going to cost you more than that. It's going to cost your clients more than that. to go to a hearing on this matter. So go out and talk to them. And for me, that's been very effective, to get people to settle cases. Custody cases, emotions are always running high. That's why you can have a custody case that's 15 years old and has an 18-page docket and has this much paperwork in the file. But once again, when I'm meeting with the attorneys and with the people, I say to them, you have a right to a hearing. You have a right to be heard. But do you really want to be a perfect stranger stepping into your living room and telling you what to do with your children? Or do you want to tell them? Maybe you want to talk about it. Now, there are certain cases where folks just can't stand each other, even after 15 years, and they won't talk. And in that case, you have to have a hearing. I agree with Attorney James that justice delayed is justice denied. I'm just looking at my own schedule. When I hear from attorneys that they need 4 days to do a trial, I can't find 4 days together until March. And why do you want to do them together? So that people don't forget what happened. Okay, and it's still fresh in your mind. Even finding full days that are open. Somebody says, we have this custody matter that's going to take 1 day. We're in February already. Because keep in mind, the judge isn't just doing custody, divorce, support cases. The judge is doing children and youth cases. The judge is doing protection from abuse cases. The judge is doing civil lawsuits, which run the gamut from property disputes to contract disputes to any reason a neighbor might sue their neighbor. When you get into the criminal system, which I'm responsible for 1/3 of all the criminal cases in Columbia and Montour County. We just today had what's known as call of the list in Columbia County. We have that every other month, an odd number of months. There were 747 active cases on the call of the list that I had to go through this morning. Think about that, folks. 747 cases. I don't know how it got there. Can't speak to that issue, but that's what we have in front of us. And that is better than 2 months ago or 4 months ago, it was up around 800. So it is slowly coming down. But that's a criminal takes up an inordinate amount of my time. All day long today was criminal court. I'm also the PFA judge, so interspersed between doing all the criminal hearings and the 747 cases on the call list, I had 2 emergency PFAs come in that I had to hear. So, it's great to talk about speeding the system up, and I assure you that the president judge, the court administrator, and the other 2 judges are doing everything we can, especially now that there's a 3rd judge, to speed the system up. And there's always better ways to do things. And we, the judges and court administration, are always open to new ideas and trying to do things better. And we will continue to do so. And it takes work. Being a lawyer takes work. I used to get emails from Attorney James at 6:30 in the morning. And I think he'd be done by 6 in the evening. Can't blame him for that. But my day would go from 8 in the morning until 8:30 or 9 o'clock at night because I'm at some sort of municipal meeting. So, you have the work ethic, certainly Attorney James does, and certainly I do, for this position. And it's a duty to the law, but I also see it as a moral obligation to the people in Columbia and Montour County to do the best possible job I can do, to be as informed as I can be about their case, and that takes time. Has that answered your question?
Yes, thank you.
Okay, thank you. Any other questions?